My name is Michael Busby. I am a Texas family law attorney who practices family law in the district courts of Harris County, Texas, and the Fort Bend County district courts. In this video presentation, I will go over acknowledged fathers and presumed fathers. An acknowledged father is a father who has signed an acknowledgement of paternity. Many times the acknowledgement of paternity will be signed at the hospital at the time the child is born. However, you can also go to the Attorney General's office and sign an acknowledgement of paternity. These are forms for which the father states that he is the father of the child, that is verified, and the mother signs as well. The document is then filed by certified entities that have an entity code with the Texas Bureau of Vital Statistics, and that establishes a parent-child relationship as far as allowing the father then to claim certain rights as to the child. It gives him standing to file a suit for possession and access. It allows the child to inherit through the father if the father were to pass away or collect Social Security. Now, a presumed father works a little differently, and the presumed father can occur under any one of the 5 factual circumstances. As I state to you, a child is born during a marriage between the man and the child's mother. The man married to child's mother and the child born before the 301st day after the marriage is terminated. The man is married to the child's mother before the birth of the child, even if the marriage is voidable. The child is born on or before the 301st day after a voidable marriage is terminated. The man's married to the child's mother after birth of the child, even if marriage is voidable, and the man voluntarily asserted his paternity of the child as evidenced by written assertion filed with the Vital Statistics Unit, or man is voluntarily named as father on birth certificate, or man promised in a record to support the child as his own. During the first 2 years of the child's life, the man continuously resided in the child's household and represented to others that the child is his own. So as I read the presumptions here in these categories, many times the issues arise which are having to be troubleshooted by attorneys in the courts as to same-sex marriages. 2 women get pregnant, and then what are you going to do as to paternity? So you'll have to enjoin the fathers, the gentleman who had sex with the women, or if there was some type of gestational agreements, you'll need to produce those, and you'll have to explain to the court the status of the father. A void marriage is typically where someone is married to someone else and that marriage has not been terminated. And so if you think you're married and you have a ceremony, but you're unaware your spouse was married to someone else and that marriage has not been dissolved, that's potentially a void marriage. Also, if you are under the age of 18 and you have a marriage and you do not have judicial consent, that marriage is void in Texas. So those are a couple fact patterns to give you to explain the details as to these categories of a presumption of paternity. Now, the presumption can be only overcome by adjudication, which is the filing of a lawsuit, and you have to adjudicate paternity to overcome the presumption. Generally, a proceeding to adjudicate parentage of a child having a presumed father must be brought by the presumed father, the mother, or another individual who may be a person who has actual possession of the child, child protective services, or another gentleman who claims to have had sexual relations with the woman and to be the father of the child. The proceeding must be commenced no later than the 4th anniversary after the birth of the child. However, a proceeding to adjudicate parentage may be initiated at any time if the court determines that the presumed father and the mother did not live together or engaged in sexual intercourse with each other during the probable time of conception, or the presumed father was precluded from commencing a proceeding to adjudicate the parentage of the child before the child's 4th birth date because of the mistaken belief based on misrepresentations led him to believe that he was the child's biological father. So this is generally where the woman has had affairs and told the husband that she's pregnant, they have a baby, and as the baby gets older, the baby looks nothing like the father, and the father does a DNA test, her husband does a DNA test, and it comes out the child's not his, and it's been more than 4 years. And so many times the women will say you're time barred because of the 4 years, but then you have a what's called a fact finding by the court, and with the fact finding by the court will look at the time that the father knew or should have known that he was not the father, that the husband was lied to. And many times you'll have men who cannot have children, and they'll be in love with a woman, and then there'll be agreements that the woman can have outside relationships for the purposes of getting pregnant. And when she's pregnant, she's supposed to stop, but then she keeps having extramarital affairs, which creates a jealousy situation. And so, like I said, it's a fact-intensive examination, but you can, and I have prosecuted cases that are beyond the 4 years if you have facts which show deception on behalf of one of the parties, which is generally the woman. The suit to establish the parent-child relationship is also part of adjudication. A child that has no presumed, acknowledged, or adjudicated father, this type of proceeding may be commenced at any time to adjudicate a potential father of a child. Now, challenges that you may make to the paternity, mistaken paternity is going to involve the filing of a suit to terminate. And so a man may sue to terminate the parent-child relationship between the man and the child if, without obtaining genetic testing, he signed an acknowledgement of paternity or was adjudicated to be the father of the child in a previous proceeding in the family law courts. This pleading must be verified and must allege facts showing that petitioner is not the genetic father, petitioner signed the acknowledgement of paternity or failed to contest the parentage in the previous proceeding because of a mistaken belief he was on the child's birth certificate, and that the mother told him that he was the father of the child. The petition must be filed no later than the 2nd anniversary date on which the petitioner became aware of the facts alleged, indicating the petitioner is not the child's genetic father. So this is how you get around the 4-year requirement that is your statute of limitations to contest paternity when you are otherwise adjudicated, or there is a presumption of paternity. The court must conduct a pretrial hearing to determine the existence of a meritorious prima facie case. So generally what you do is you go get a home DNA kit, you take the test, that quality control and chain of custody for those DNA kits are usually attacked, but that'll give you enough evidence to have a court-ordered test in which there'll be enhanced chain of custody controls. And once you have the second test, then if the second test excludes you under this family law section, which is the suit to terminate under 161.005 of the Family Code, the statute reads, if petitioner is excluded, order of termination shall be entered. So that's a shall statute. That means the court has no discretion. The order of termination does not affect your existing child support arrearage. So if you have an order out there that you're paying child support on from several years ago, you're still going to have to pay that. But it does terminate future child support obligations and interest obligations. The prior existing obligations can still be enforced by contempt. If requested by the petitioner, the movement father, the court may grant post-termination possession access if the court determines that denial of such periods of possession access would significantly impair the child's physical health or emotional well-being. The court may require that the child or any party participate in counseling, and you would still have certain rights and duties if you have possession access for a period of time as to the child, which would be during your period of possession to consent to basic medical care, religious services. And so many times the man will want to walk away because the woman usually is going to be having problems with the child because she lied both to the child and to the man. And so the man will try to get as far away from the couple as possible. However, many times there'll be a situation where the physician and the child will go through some form of counseling, but what I've seen is that most men don't want to do this, and many times the woman will find who the actual father is, and then that new relationship will start, and then the father, who is the actual biological father, will come into the picture and start to exercise his periods of possession, and then there'll be the blossoming of that relationship with the child's actual father at that time. My name is Michael Busby. This video presentation was on acknowledged, presumed, and adjudicated fathers and termination of the paternal relationship based on genetic testing on mistaken belief of the father that he was the biological father of a child. Thank you for watching.